everybody. You know the drill. If you have a question, please put it in the Q&A section up top. Don't put it in the chat. I do not monitor the chat, but I do monitor the Q&A. Throughout this session, we will have 4 polling questions. If you need to get CPE, you must answer at least 3/4 of the polling questions. So make sure you watch them. I can't tell you when they're coming up. Okay, with housekeeping items out of the way, let's get into this. So we came up with a topic from hearing it from certain people and what we see with our clients going on about labor and employment issues. Now, the one thing that I will say is that I want to issue a disclaimer or a qualifier, because our presenter today is extremely knowledgeable in the area. We had a pre-call, talked about a lot of stuff. However, this stuff changes. So Katie will give you some great information, but I strongly recommend that if you really have an issue that you reach out to them and talk, because who knows what can happen. So I just want to put that's my disclaimer for her. She'll give a disclaimer for my disclaimer. So that's her legal responsibility. So our speaker today is Katie Foreman. She's counsel of Porzio, Bromberg, and Newman. Great firm, known them for a long time. So Katie, I want to thank you for coming. This has been a crazy 2 years. If it wasn't crazy enough going into it, it's even crazier the past 2 years. You don't know what we can say, what we can do. I've got my human resource director on speed dial because I notoriously say something stupid. So was I okay saying that?
I can't imagine.
If not, can we issue an apology right now? Okay. So, but if I spoke with you 2 years ago today, I imagine your comments would be different than they are right now.
They certainly would. They certainly would.
Yeah, and while I love history and would love to talk about that, I don't want to waste our 50 minutes to an hour talking about that. And I'd love to hear what's happening. Are we still talking COVID at this point?
We are still talking COVID, but the conversation is changing a little bit. Okay. When we first started talking COVID 2 years ago, there was a lot of guessing, about what would happen, what the CDC would say, what the Department of Health would say, what the Department of Labor would say, what the EEOC would say. We know that now. We know the answers to those questions. Now that we're hopefully emerging from the pandemic, the questions that we're seeing lately are ones that are sort of on the tail end of the vaccine issues, right? Folks know at this point that employers can mandate vaccines as long as they allow employees to apply for exemptions for medical and religious issues, medical contraindications, and sincerely held religious beliefs. And also in certain sectors, the government is actually requiring folks to get vaccinated or to be vaccinated and test. So I would say probably beginning about a year ago, we started fielding a lot of those questions on what constitutes a religious exemption, what constitutes a medical exemption. Are those exemption evaluations even necessary if we just allow people to test instead of requiring them to be vaccinated? And generally speaking, we don't see a lot of medical or religious exemption issues in a policy that allows for a testing option. We did see one. We actually saw one come across where someone said that the testing was actually contrary to a sincerely held religious belief. We were able to recommend that person actually be accommodated by undergoing a saliva test instead of the nasal swab, and that worked out. But really, we're emerging more from those issues, and we're seeing a lot of questions about leave because, childcare is still becoming unavailable due to COVID. And that's something that people have been struggling with from the beginning of the pandemic. And that still is an issue in a lot of circumstances where there's a close contact and a child is sent home from school and a parent has to miss work. What protections are available in that situation? So we're seeing some of that. And we're also seeing a lot of questions about long-term issues as far as returning to work. Folks have been fully remote or on a hybrid for a while, and some workplaces are trying to bring people back in full time or to work out an arrangement where there can be some long-term remote work options available or long-term hybrid option. As far as the leave is concerned, we're encouraging folks to really look at those laws, look at the New Jersey Earned Sick Leave Law, look at the New Jersey Family Leave Act in the event that you have more than 30 employees. And if somebody actually is sick with COVID or long COVID, to the extent that it's a serious medical condition, look at the disability accommodation requirements under the New Jersey Law Against Discrimination and the Americans with Disabilities Act, and look at the FMLA. We have had some clients, feel as though they need to be granting FMLA leave for COVID-related issues. That's not necessarily the case. Every case of COVID is not going to trigger an FMLA protection. Some people will have serious medical conditions because of COVID, and at that point, the FMLA protections might be triggered. But generally speaking, a typical case of COVID or just an exposure is not going to trigger a leave accommodation under the federal FMLA. So really just looking closely at those laws and those cases that come up on a case-by-case fact-specific basis to see, what, if any, protections an employee might be entitled to leave-wise. That's what we're encouraging folks to do there.
So you hit on a couple items, and I was actually at a polling question as it relates to it, so I'm going to put it up. And I can understand about the whole vaccination is it's going back out to sea now, it seems, because at this point, this is an editorial comment by me, not by you or your firm or my firm. It seems that if somebody was going to get the vaccine, they were going to get the vaccine at this point, okay? Unless they had different reasons. Was a company allowed to ask somebody what their religious reason was, or if somebody cited religious reasons, you just had to accept it and move on?
So when somebody cited religious reasons as an exemption, companies were allowed to ask for supporting information. We were recommending that folks keep that really open-ended and allow employees to provide whatever information they felt supported a determination that they had this sincerely held religious belief, and that it was part of a larger scheme of a sort of comprehensive scheme of a sincerely held belief that could be religious in nature. Under under Title VII and those protections, a religious belief is entitled to the same protection as a lack of religious belief. So you can't necessarily ask an employee to tell me, okay, well, what religion are you? Okay, well, the person in charge of that religion hasn't said anything about vaccines, so we're not going to grant you this exemption. That's not how the analysis works. Folks are allowed to provide their own information, and we've seen a lot of different submissions in support of those sincerely held religious beliefs. Some of them we've encouraged our clients to grant, some of them we've encouraged our clients to deny. But generally speaking, it doesn't have to be mainstream. And even if the mainstream message of a particular faith is go ahead and get vaccinated, some folks in some smaller groups of particular religions are finding that their religious leaders are saying, no, we don't believe that you can get vaccinated and still hold this belief. So we're encouraging you not to. And even those smaller groups within those faiths, as long as folks are providing sort of a rational explanation as to the connection between their religious belief and the contradiction with the vaccine, we are encouraging employers to grant some of those requests.
And this is not for you, but I know that a couple of the attendees work at organizations where a lot of people come in, and they may had to ask. Let's say we're in California and they ask for cards, and say, I want to see your vaccination card, or you can't come in. It's like, well, it's my religious exemption. This is a labor session, not a public policy session. Okay. Yeah. But you see how difficult this could be, this concept. And I imagine, not you, them, I'm saying they should reach out to the attorney, because bigger companies may have the resources, smaller ones sometimes, they just talk in the office and say, oh, come on, what are you, crazy? You think that type of thing? That's where you can go over the cliff. And since you talked about that, I'm just going to put up a poll real quick asking our attendees, and we'll leave it up for about a minute, so answer as quick as you can. But you also mentioned daycare, and and there's another polling question I have on that too. A lot of people have been working from home, and we have other topics that I'll address on this too. But people working from home, and either they couldn't get daycare or they opted out of daycare, and now because they're working from home, they feel they could save money now. Does the employer have the right to say to that employee, you should be getting daycare because it's disrupting your work?
Yes, even if it's not disrupting your work, what we would recommend is at the outset of a long-term telecommuting relationship where an employee is going to be working remote, either on a hybrid schedule or full time, we encourage employers to have a conversation about expectations before that arrangement even begins, or at least before it begins formally or long term, and document in writing what those expectations are. And one of those expectations should be that the work environment at home is quiet and free from disruptions. To the extent that that involves, getting childcare, an employer is absolutely allowed to require that. Some employers even require proof in writing that an employee has childcare during the times that they're expected to be working remotely.
And that's interesting. The concept you just said, and free from disruption. So I can ask my wife to move out.
Well, that's a little more of a personal issue, but
I was asking a legal question. I'm sorry.
I'm not a family lawyer, so
okay. Never mind. No, but that's very interesting what you're saying, because I'm trying to mix it together, because everybody's saying, well, the work day has evolved, and we at Sobel and Company have tried to say the work days evolve. We know with the way life's going, you may have to run to the store, you may have to run and pick up the kids, or a parent even, or a family member that you're caring for. And you might be working at 8 o'clock, 9 o'clock at night to kind of fill the time in. At Sobel and Company, we tried to say, okay, but we would expect that you would be at a minimum, let's say 9 to 3, and you're filling in on the front end, the back end, someplace else. Mm-hmm. So to your point, the company should document what the expected window is at least. It could be 9 to 5, who knows? And then in there, you should have the environment that's free from disruption for your own sake and for other things that are going on. Okay, that's interesting.
Sure. So yeah, first of all, those conversations are a lot easier to have at the outset, right? It's much easier to set the expectation than it is to approach the employee after you've realized that they are not productive in a remote work arrangement, or there are too many disruptions. So we strongly encourage folks to have actual written agreements where employees acknowledge those expectations before engaging in the remote work relationship. But to your point about flexibility, the scenario you described works very well with exempt employees, right? Folks who are higher level employees, who are salaried, who are not entitled to overtime under the state and federal wage and hour laws. To the extent that you can afford them flexibility to, work throughout the day, work at night if they need to fill in, get caught up, fill in some gaps. That works great. It's a little more difficult with non-exempt employees, and anybody who is engaging in a telecommuting relationship with a non-exempt employee needs to be very careful about how that employee's time is documented, what that employee is expected to do during a period of time when they are not actually on the clock, when that employee takes their breaks, and really just making sure that folks are not working overtime without approval, without the employer knowing, because that runs into a situation where obviously if the employer doesn't know about it, then they're not going to be compensating the employee for the overtime that they're working, which is going to run into a major problem under the wage and hour laws, because that's not going to be a defense if the company gets audited or if the employee ends up filing a complaint. So to the extent that an employer does want to engage in a remote work relationship with a non-exempt employee, these are folks, who are entitled to overtime under the classifications under federal law and state law. We strongly recommend that there be very specific systems in place, and that the documentation be very careful, just to make sure that those folks are not going over 40 hours a week. And if they are, to make sure that they are being compensated.
Okay. Yeah, that's one thing that you said was a written agreement. Now, and people get nervous. We're in the electronic age. Is it okay to send out, I'm going to use the common one that people use, I don't mean literally, but okay to send out a Survey Monkey or a check the box and it automatically logs your response? Is that acceptable as to you in saying that you, well, I guess I see on every app I sign up on my phone where I just click it and go, I agree. But I do read all the legal terms. So you just say that.
Oh, sure. We all read all the terms and conditions, right?
There you go. I guess that would be acceptable as to a written affirmation.
We would recommend having something a little more individualized
Okay, wow.
and a little more tangible, because, look, nobody wants a relationship to end with litigation, but the fact is that sometimes they do. And in the event that you have somebody's written and signed acknowledgement pertaining specifically to their situation with their name on it, that can be evidentiary if you ever need to defend yourself in litigation. That's obviously, everybody wants to avoid that. Nobody wants to anticipate that at the beginning of a relationship or while a relationship is going well. But the fact is that if you do get sued, you'll be very glad that you have that document. So we would recommend doing that as a written and a more particularized agreement, as opposed to having somebody just check a box online.
Yeah, Alan Solo, our managing partner, I know he didn't coin this phrase, although he's still trying to collect royalties on it, is it's not a problem till it's a problem.
Exactly.
Right.
Exactly.
Yeah.
By the time you're on the phone with us, it's a problem, and we're going to ask you where that agreement is.
Exactly. Yeah. And Colleen, I know you can hear me. I unfortunately, I got a text from somebody that says that their browser is still saying trying to get admitted. So it was Ken who, joins regularly. I just wanted to let you know. I don't know if there's anything you could do. I know that you had touched on leave a little bit. I don't know if there's anything else you want to expand on that.
We would just recommend that in a particular situation where somebody is finding that they need to be absent for any COVID-related reason, doing an analysis with their particular situation and circumstances to see if there are any protections available for them, before denying leave, or before, letting them know that that they're going to have to either use their accrued leave or that they're going to have to take unpaid leave. We just sort of recommend going through the statutes and see if any of them apply to their particular situation, right? You have the New Jersey Earned Sick Leave Act, which is going to have some coverage, obviously, for employees who actually are sick, or for employees who are caring for somebody, or for a child who is sick, or if there isn't childcare because of COVID. You're going to have the New Jersey Family Leave Act for folks who have more than 30 employees. If an employee's been there for a year, they'll be entitled potentially to some of those protections, which were modified in 2020 to allow for some COVID-related leave reasons. And then for folks, who are more seriously ill, you have the disability accommodation laws, and you've got the FMLA. But those are going to be folks who are really suffering from severe COVID-related complications, either of their own or having to care for somebody who has them. If you're looking at the FMLA, typically for something to be a serious medical condition under the FMLA, it requires a hospitalization and ongoing care from a doctor. So, a mild case of COVID is certainly not going to trigger that, but unfortunately, some folks are more severely ill, and at that point, it may make sense to look at the protections under those laws as well. The FMLA covers folks with more than 50 employees, and it's an employee who's been there for at least a year.
Yeah, the whole Paid Leave Act. I mean, New Jersey put it into effect. I've been practicing for 34 years, so not a long time ago to me. Could be 20 years ago, and it hasn't been an extremely long time. Compared to the Fair Labor Standard Act from back in before I was born even. And I find that people and companies still don't understand. And even I was talking with my wife one day at the table. They said, "Oh yeah, well so and so gets that kind of time off." I'm like, "Really? Why would they get that much off?" And she's like, "Everybody does." I'm like, "According to what?" And I should know this, But does this also? I mean, because I guess that's like the ending, not the end of COVID. I wish it was, but that's the last area of COVID for the most part. I know that there's some other topics that COVID kind of weaves into, but as you said, it seems that a lot of that is going out to sea now. Let's hope the whole issue is. And there's some other areas. I know there's like wage and hour issues that are coming up.
Mm-hmm. Sure. So one of the things that we're seeing lately in New Jersey and federally is a major push to crack down on misclassification of workers. So when we speak to that, we're talking about the distinction between somebody who's employed as an independent contractor I'm even saying it wrong. Somebody who works as an independent contractor, because an independent contractor is not employed, or somebody who is an employee of a company. And a lot of folks think that as long as you put somebody on a 1099, and call them a consultant, they're an independent contractor, but that's very much not the case. And New Jersey is really, really in particular looking to stop those sorts of arrangements from being classified as independent contractor relationships, and to make sure that those are classified as an employee relationship. And the reason is it's not just tax reasons. There are entitlements for employees, such as temporary disability and unemployment, that they may not get if they're independent contractors as opposed to employees. So the state's making sure that folks are really protected in those relationships. One of the things that New Jersey has done back in July of 2021, Governor Murphy signed into law some legislation that will enhance the penalties for misclassification. There will be increased civil penalties, and also it actually permits there to be stop work orders in situations where there's misclassifications. And he also enacted a task force that will actually go around and conduct random audits to make sure that folks are not being misclassified. So to give sort of a rundown of where we are in the law with respect to actually classifying employees as I did it again, classifying workers as independent contractors versus employees. The test that typically tends to be in use, that's the most universal test. There are quite a few tests that sort of float around, particularly in federal law. But in New Jersey, the primary test that's used is what's called the ABC test. And the A of the ABC test is whether the contractor has sufficient control over their own work, right? Whether they're making their schedule, whether they're having discretion with respect to how the work is done, as opposed to whether the company is telling them specifically exactly what has to be done and when. So we look, obviously that's going to be a fact-specific test, but we would look to how much control that contractor has over the work that they're doing. If the company is exercising a very high degree of control, it's less likely to be considered an independent contractor relationship, more likely to be considered an employment relationship. The B of the ABC test looks at the business, right? So there are two different prongs of this. One is whether the work that's being done goes to the actual purpose of the business, right? So if you are a company that provides accounting services, and this person who you've hired as a consultant is providing accounting services, then what they're doing is contributing to the actual purpose of your business. So that will make it more difficult for that person to be classified as an employee as opposed to an independent contractor. One thing that courts or the DOL will look at when they're evaluating that is whether the person is on site or whether they're in a different place of business doing the work. And if they're not at the company's business that they're contracting with, and they're actually doing the work elsewhere, that will weigh more toward classification as an independent contractor, even if they are contributing more toward the purpose of the business. What I haven't seen yet is whether somebody who's in a remote work arrangement working from home will be considered outside of the business or not. My prediction, I have to admit that I haven't done a very exhaustive search as to whether this has come up yet. But my prediction, if it hasn't, is that that's still going to be considered part of the company's business, even if it's just a remote work arrangement. If you've got somebody who's an actual contractor who is in business for themselves, they're likely to be conducting other kinds of business out of this other location. And that would weigh more in favor of that person being an independent contractor. And that also takes us to the C part of the test, right? Whether they're in business for themselves, working for other entities or clients. And that's really one of the most determinative factors. And in fact, there was a case recently where somebody met every single other requirement of the ABC test, but they just were only working for one company. And the ultimate determination on that was that person was actually an employee because they didn't have income from other sources and they were working exclusively for one entity. So I'm sorry, go ahead, Brad.
Yeah, I find this very interesting. I agree with what you're saying, that I've seen this in practice. I saw, and while I'm asking this, question or make a comment, I'm just going to put this polling out there. I had a client that, to scare people that are on here, let you take a drink. I had a client that got caught for paying himself, he's a sole proprietor, but a corporation, paying himself as a contractor.
Mm.
And the IRS came in and said, you can't be a contractor to yourself. And what they did was they went back to X amount of years and hit the company with the Social Security, Medicare, estimated federal income tax withholding to, in essence, issue him a W-2. He then had to go back personally and amend his tax returns to try and collect the money back, of which some of them were out of statute. And then I had a friend who was a true sole practitioner accountant who paid his daughters to come in and just do the filing and gave them a 1099. And when the state of New Jersey came in and said, okay, that's fine. They come in whenever they want. You don't control them. You don't direct them what to do. You know, the old IRS 21-step test, which they just mentioned. However, do they do this for anybody else? Your last test. What does your daughter do? Oh, my daughter's a teacher. So this is not her regular business. But the real thing that I find very interesting, over the many years that I've been practicing, and in New Jersey, I've seen a lot of these larger corporations terminate people and immediately bring them back as contractors.
It's not impossible to do that legitimately, but you have to be very careful about what those folks actually are doing. And you have to really make sure that they are then moving toward being in business for themselves. Just bringing them back as a consultant and calling them a consultant is not going to satisfy any of those ABC requirements. But it's not impossible to transition to that relationship if somebody actually is going to, you know, potentially maybe open their own LLC, start marketing themselves to other entities, and also continue performing work for their former employer. It can be a legitimate arrangement, but it just has to be done carefully and well documented.
Yeah, and I'm hoping that they don't have the clout in the state not to get pushed, and these smaller organizations need the direction as to what to cover themselves about. And I'm not saying illegally or nefariously, but cover yourself, because I've been through the audits. You've heard of this stuff. Ellen asked, and I don't know if you know this, is New Jersey unemployment records from COVID, is New Jersey using unemployment records from COVID to find companies to audit? I don't know if you would know.
I don't know what their process is for that. I do know that random audits were part of the legislation that Governor Murphy signed. So, you know, to the extent that there's any particular process for selecting randomly, unfortunately, I don't know what it is. But to Brad's point, as far as the penalties go, you know, when there's an audit, the tax audit and the labor audits are two separate things, right? So there are, you know, we've been through labor audits with our clients where they've been accused of misclassifying employees, they've been accused of not paying overtime. The audits are painful and the penalties are steep. So these are things that you really do want to have buttoned up.
I mean, in the end, for more than likely, yeah, is the state losing income tax on it? Maybe a little bit because somebody's taking expenses against it. Maybe some there, but the unemployment and disability is what they're missing by people not being classified as not being classified as employee, and that's what they really want to go after, and possibly workers' comp too.
Yes.
Yeah, and so but this is a hot area. I've seen a lot. Anything else on it you want to mention?
No, there actually was a case that came out last week, which maybe it was earlier this month, but at some point within the last couple of weeks, there was a case that came out involving drywall installers. The New Jersey Supreme Court ruled on it. And it was interesting. It found that the emphasis was really on the whether they're in business for themselves piece of it, right? And so there was a group of drywall installers, and the state was looking at whether they had been classified or misclassified as independent contractors as opposed to employees. And ultimately, the Supreme Court's decision sort of split it up, and they drew the line at whether the workers were in business for themselves. So there were certain contractors that they held were they weren't contractors. There were certain workers that the New Jersey Supreme Court held had been misclassified because they were only working for that particular drywall company. And then there were other workers that they said were truly independent contractors who had not been misclassified because they were doing work for other entities or other companies. So, you want to make sure that you can check the boxes on the ABC test, but the true consideration when you're looking at classification is whether this is somebody who's really in business for themselves or not, or whether this is somebody who is actually just doing the work for your company and more so functioning as an employee.
Yeah, and there's you want to make sure make sure you're documenting and covering yourself properly, because I see at least 3 different ways that you can get caught in this area: IRS, state of New Jersey, or a typical workers' comp audit, from your workers' comp insurance company. And while they may or may not cross and tell each other, I don't know, and I'm not trying to guess or speculate in any way, but IRS is going to get you on the federal level. At least they could tell the state what you get you on the state level, who could tell you workers' comp, and workers' comp could tell the other one. And at some point, I have a sneaky suspicion all of this is going to be tied together, where as soon as one is told that I'm on the New Jersey Society Professional Conduct Committee, and pretty much what the AICPA Professional Conduct knows, the state board knows, and we know. And pretty much it's a circle that tells everybody to make sure that there's proper oversight. At some point, those 3 will probably be talking.
Yeah, that certainly makes sense. And to your point about documentation, one of the important takeaways is that anytime you're going to consider a relationship to be an independent contractor or consultant relationship, you absolutely have to have a written agreement with that person that sets forth that they are a contractor, that they are not an employee. They know they're not an employee. They know that they're foregoing the benefits that an employee would have. Because anytime that there is an audit, that's going to be the first thing that the Department of Labor asks for. So your point about documentation is well taken.
Okay, it was another issue that we've seen coming up, and it's a sensitive issue, and for some people in hearing and what's going on with the politics and everything. I don't even know if I'm using the proper word, so I apologize in advance if I offend anybody, but transgender, what do companies have to understand and know or do we not care? I don't know.
So the most important thing to know about transgender employees at this point in time is that under New Jersey law, under the New Jersey Law Against Discrimination, gender identity is a protected status. So somebody who identifies as transgender or who identifies as non-binary, which would be, sort of gender neutral, those folks are protected under New Jersey's law against discrimination. Under the statute specifically, gender identity is actually a term that is used in the statute. And there also is protection at the federal level as of 2019, even though Title VII, which is the federal non-discrimination legislation, doesn't expressly say that gender identity or sexual orientation are protected statuses. In 2019, the United States Supreme Court held that where there is a protection for gender in Title VII, that includes gender identity discrimination as well as sexual orientation discrimination. So discrimination on the basis of those statuses is prohibited under both state and federal law. And what that means is that an employer can't take an adverse employment action against an employee on the basis of that person's gender identity. And we'll sort of define that broadly to mean anybody who doesn't identify as a typical gender normative identity, right? So somebody whose gender identity is different than their biological gender, that is a person who would be protected as far as state and federal law are concerned. So an employer cannot decide to hire somebody based on their gender identity. An employer cannot fire somebody or demote somebody or decide not to promote somebody because of their gender identity. Those would all be adverse employment actions. And those things are sort of obvious, right? But the trickier part comes as far as preventing a hostile work environment and protecting employees who identify differently from a hostile work environment, making sure that they feel safe and included in the workplace. And that to the extent that there is any sort of harassment or anything that would infringe on their legal rights, that they know how to report that, and that the company is undertaking reasonable efforts to prevent and remediate any sort of harassment that could be occurring. Best practices wise, one of the most important things that we're seeing as far as making sure that employees with differing or not typical gender identities are comfortable in the workplace is making sure that their pronouns are respected. Anybody who tells you, that they identify as she or they, even though, biologically you might think that it would be otherwise, it's very important for those pronouns to be respected in the workplace. Very important for employers to use employees' preferred names in the workplace. And that's not even just a gender identity issue. That can be a national origin issue as well. Folks who tell you that they want to be called by a particular name and that this is how you pronounce that name. It's very important to make sure that that's respected across the board.
So I had a question from earlier that I didn't want to interrupt because you were on a great roll. This is going to sound weird, but I remember it was a lawsuit on prior convictions as it relates to applications. I haven't filled out an employment application in a long time, and I know that was a trick question that Alan wanted to know if I was filling out an employment application someplace. Okay. And I remember years ago, it used to say on employment applications, male or female. Should that be removed from the employment applications, or expanded?
It doesn't. So it depends on when you're providing the employment. First of all, it depends on when you're providing the employment application, because certain information might be useful in terms of evaluating your workplace demographic, right? You might want to know what that gender breakdown is so that you can make sure that, you're actively promoting women in the workplace, and you're actively, making sure that there is equal representation for various protected groups. So to the extent that you're using demographic information for that, we would encourage having it filled out, after the person interviews and is extended, or at least after the person is granted an interview, so that you can, use that information for those self-evaluation purposes. It certainly would not hurt to include on the form, regardless of the stage at which you're presenting the form, prefer not to answer, or or non-binary or other, and allowing somebody to provide that information. But because it is sensitive information, we would encourage you not to put that on the form at the outset, right? So that shouldn't be the first thing that the person tells you about themselves when they're applying for employment.
That's, and I was actually use the word other, and I'm sitting here saying, can I say other? I'm starting to sweat thinking what I can and can't say.
Well, you can allow people to self-identify, and that's a way to do it, right? So you give folks the option to provide their information.
Gotcha.
Obviously, you want to word that in a way that's as sensitive as possible, and other might not be the best way to do it. But if you sit down and give some thought to how you'll permit folks to self-identify, or even just, maybe it wouldn't say other, maybe it would say their preferred pronouns, but just give folks the opportunity to provide you with that information, and then respect the information that they provide.
Now, you say proper pronouns. Is it on the employee?
We say preferred pronouns. Preferred. Yeah.
Preferred. Okay.
That's okay.
And I'm not making light of this situation. I'm making light of it. So the wording is so difficult, and it's actually one of our next topics too. Is the preferred pronoun the obligation of the employee to tell you, here's what I prefer? Or is it okay for the employer to assume what I see, what I think is biological, is what I'm going to possibly say? Or you should never do that. You should ask them up front, what do they prefer?
So it's ideal not to assume in general. But if you are going to ask folks to share their preferred pronouns with you, we would recommend making sure that you have something in place where you're really asking everyone to do that, and you're not singling a particular person out because of the way that you're perceiving that they look, right? If you're asking somebody their preferred pronouns because you're suspecting that they may not identify, with their biological sex, then, that person might feel as though they're being targeted with that question. So if you're wanting to know somebody's preferred pronouns, that might be something that you would ask, after that person is given an interview or after that person is offered employment. One practice that's certainly not required, but something that a lot of organizations are doing in order to make transgender employees feel more comfortable is to have everybody provide their preferred pronouns either in their, or to encourage, not require, but to encourage everybody to provide their preferred pronouns in their email signatures or in other forms of introduction to sort of normalize it so that folks who, are being asked to do that are, feeling more comfortable providing that information, or folks who want to provide that information are feeling more comfortable providing that information.
Okay. Now, how about accommodations? I know that ADA has accommodations that are required for physical handicaps, and this is not a physical handicap in any way, but there are accommodations, bathrooms. You see, I'm trying to couch my words as best possible here. Are there facility accommodations that have to be required, provided for transgender? Bathrooms for the most part.
So it's generally a good idea if your facility can accommodate it to have an option for a restroom that's not gender specific. But in terms of an actual requirement that somebody be accommodated with that, I think if an employee approaches human resources or management and says, this is what I want, then you would obviously engage in the interactive process with that person, just like you would with respect to any other accommodation. It's not a disability, of course, but, we would strongly encourage folks to be having that conversation to make sure that their employees feel safe and comfortable. But, we wouldn't necessarily recommend that you approach the employee with that question, right? If somebody comes to work for you, they tell you that what their preferred pronouns are, and then you discern that, maybe those pronouns don't align necessarily with that person's biological sex, we would not have you then ask that person, what bathroom are you going to use? That would probably actually go more toward creating a hostile work environment than it would toward making that person, feel accommodated and welcome. So, we would certainly encourage you to let that person start the conversation about, what they need. The best way to sort of address that at the outset would be to just have a policy in place where employees, understand that the employer does not tolerate, there's a complete zero tolerance policy for any sort of discrimination or harassment, and that gender identity is included within that policy, and that the person knows, not only or that all people, not just the person who may be protected, but that all people know that unlawful discrimination and harassment is not tolerated in the workplace, and that there is a very specific reporting mechanism for it, so that if that person is made to feel unwelcome based on their gender identity by anybody in the workplace, they know exactly who they can talk to, and that person will, and that the contact that they're directed to will immediately take action to remedy what's going on. That's probably the number one thing that employers can do to protect transgender employees.
I mean, and you see, I know that this is a fairly politically sensitive topic, which you hate that it is that way, because it should just be a topic that people should understand and talk. And Sobel & Company is very sensitive to this topic in general, and I'm nervous about what to say. And the people that are attending know that I'm very, very freewheeling. When you see me, stuttering on what to say, I want to make sure that I'm not offending anybody in any way on a topic like this. And what a way for me to segue into a poll, huh? I mean, I don't have a poll relating to this. Let me see. Let's hit this one. So, in line with what the little editorial comment I made at the end there of what I can say, what I can't say, how I can say it. I'm one of those ones that Molly in her office, our HR director, I don't want to give out her full name. Anytime I go like this, she's like, "Oh no, what's he gonna say? Oh no, what's he gonna say?" Because I'm a goofball. I'm fifth grade boy. It's like, it's funny, right? And they're like, no. Yeah, and it's but I'm never trying to offend, but workplace speech I'm very sensitive to is that you got to be careful what you say. Mm-hmm. Not just in general with a stupid old man dad joke type of thing, which I don't know if you could say that comment. where are we going? What's with the labor issues relating workplace speech?
Sure. So there are different kinds of workplace speech. One of the things that we're seeing that is becoming an issue, obviously, there was recently a very hotly contested election. There were a couple, right? There was the presidential election, there was the gubernatorial election, and folks are being very vocal about their beliefs, not just politically, but about various other causes, that other people may disagree with. And so a lot of our clients are coming to us and saying, well, how can we address that? What can we do, to make sure that we limit disruption in the workplace? And one of the things that we're recommending is just keeping things neutral, right? So to the extent that folks talk, there's not really a whole lot you can do to restrict employees from having conversations about things, nor should you really. And Section 7 of the National Labor Relations Act really protects employees, and we can talk about that in a moment. But the displays that employees use that can be considered speech, right? Somebody walking around with a hat on or a pin on or a t-shirt on, or somebody who's got a poster up in their office and things of that nature. Employers may want to adopt policies that require, sort of a very neutral ban on, I don't want to say a ban, but a very neutral restriction on any kind of speech that could be considered controversial, right? So dress codes are saying, you're not going to wear anything that proclaims your allegiance to any particular political group or cause, except for a sports team. Or you're not going to display in your workspace anything that proclaims your allegiance to a particular group or cause, except for maybe a sports team. Because you're better off having a generally applicable neutral policy on something like that than you are having to deal with something after it happens, right? Because obviously that person is going to feel targeted when you come to them and say, no, you need to take that down. But if you have a policy that says that you can point to that says, listen, like, nobody's allowed to have anything like this up. This is just our workplace policy. Private employers are allowed to do that. Public employers, it gets a little more tricky because then you implicate constitutional protections, First Amendment, free speech. That's generally not going to be a significant part of the consideration in a private workspace. Private employers are allowed to tell their employees that they can't engage in certain kinds of displays or speech in the workplace, provided that those policies are applied neutrally and fair to everybody. The one thing that private employers do need to look out for on that issue, though, is the National Labor Relations Act. And a lot of employers think that really deals with union employees, but it doesn't. It has a lot of protections for traditional labor and unionized workforces, but it also has protections for private employees who engage in what's called concerted activity, right? So employees are allowed to have conversations about the terms and conditions of their work environment. They're allowed to complain, particularly to one another. They're allowed to talk about their compensation. They're allowed to, engage in those discussions. And employers have to be very careful about policies that they enact that could potentially be understood to restrict that concerted activity. And in the past 4 years, the definition of concerted activity has been limited quite a bit by the National Labor Relations Board because it was a more conservative board. But under the Biden administration, it's becoming it's now a Democrat-controlled board, and historically speaking, the Democratic NLRB tends to expand the definitions or expand the protections for concerted activity, and we do see some of that on the horizon. So it's important to pay attention to what's going on in the National Labor Relations Board, even for private employers, to make sure that the policies that you have aren't going to be understood by employees to restrict that protected concerted activity.
It's interesting. You said somebody who works in the public sector, and you're talking a governmental type of agency. And coincidentally, we have somebody on here who used to work with Sobel & Company, Nick, I'm talking about you, who works for a municipality or a district. And so it's great you said that. We happen to have a lot of clients that are not-for-profits. Mm-hmm. In this, and I don't want you to go back from the beginning, but in this area or any other particular area, are nonprofits treated different or viewed different, maybe because they're getting federal funding or anything like that, to your knowledge?
So, if they're on a grant, then they're obviously going to need to comply with the requirements of that particular grant. But as far as, employment laws go, I mean, they're going to be covered by the New Jersey Law Against Discrimination. They're going to be covered by Title VII. They're going to be covered by Section 7 of the National Labor Relations Act. The only laws that we see that nonprofits may not be covered by in certain situations are the laws that require you to have a certain number of employees, because a lot of nonprofits tend to be smaller. Not all of them, but a lot of them do. So if you don't have 30 employees, you're not going to be covered by the New Jersey Family Leave Act, right? But generally speaking, nonprofits are covered by all the same employment laws as private sector employers.
And the key thing of what you said, which I hadn't even thought of, Bridget, one of our nonprofit partners, would say, Brad, how could you not think of this? Make sure you read the grant that you're getting. If you're getting something from the federal government, it could have wording in there that you will follow the certain laws that are provided to government employees.
Yes, there are certain requirements for federal contractors that would not necessarily apply otherwise. So absolutely.
Right. Okay. So one of the last areas, and I'm going to just put up the last poll just because people wait for these and they start yelling at me because, it's CPAs, because we have some of them on here. That's all they're worrying about is the CPE, which is fine. So the last topic I want to ask about is salary parity. I've been hearing a lot about this lately. And if you could just give us some background on that.
Sure. So New Jersey enacted the Equal Pay Act in 2018, and that prohibits employers from paying a person who's in a protected class differently from an employee who is not in that protected class, provided those employees are similarly situated. They do the same job, they have the same level of experience, and so forth. So a lot of employers are undertaking some equal pay audits to make sure that they are not violating that law. And it does require, quite a bit of analysis to make sure that you're compliant with that. Some employers are, one thing that also is important to remember about the Equal Pay Act is that you can't reduce somebody's salary to comply. So if you've got somebody who's not protected and somebody who is protected, and you're finding that the non-protected person is making significantly more money than the protected person, you cannot bring yourself into compliance with the Equal Pay Act by reducing that person's compensation. So that's one thing to keep in mind. It's also important.
You can't do the oops clause. I paid you too much.
Well, if you do end up needing to reduce somebody's compensation, there are legal ways to do that, but it's not going to help you with your Equal Pay Act compliance.
Okay.
However, there and compensation isn't just base salary, right? It takes into consideration, bonuses and other benefits. So that's something that's complex that a lot of employers have really been, looking into to make sure that they don't violate those laws. And then in 2020, New Jersey also implemented a salary history ban, which means that when you cannot ask an applicant for employment what their current salary or salary history is in order to evaluate what you want to offer that employee in terms of compensation. You have to offer what you feel is appropriate to offer, as opposed to basing it on their prior comp. Now, an applicant can offer that information to you, right? If you offer them something that's lower than what they're making, they can say, hey, wait a second. That's not what I'm getting where I am, and I want you to match or, do better. They're certainly able to voluntarily provide you with that information, but you can't ask for it and you can't consider it in making your offer. And something that we're actually seeing to that end, New York City is implementing a law in April that will require employers to provide a salary range to applicants so that they know what market is for the position, in order to sort of expand transparency as far as compensation goes, and to make sure that those purposes of equal pay legislation are being furthered. And one of the things that we've seen historically is that when New York does something, it's not all that long before New Jersey's doing it too. So that's something that's worth keeping an eye on, that may be on the horizon, especially because our current legislature has been active toward making sure that the Equal Pay Act got passed, obviously, in 2018, and that those protections are being furthered here.
I mean, New Jersey has it very tough, because if we do something different, we're told, well, New York or Philadelphia isn't doing it. How could you do that? We're going to lose everybody to those states. If they do it and then we do it, why are you doing just whatever New York does? Can't we do stuff on our own? So we've got it very difficult that way. I don't think this is necessarily salary parity. And I saw that Price Waterhouse said that they were going to do this. And usually they, Price Waterhouse, small accounting firm, they had said that people can be fully remote, but if you're going to work out of an office but live in a better economical area, i.e., I'm going to work out of the New York City office but live in Arkansas, they could adjust the salary structure, and I imagine that doesn't fall under salary parity, right?
So it could. I mean, it really depends on the circumstances, right? It's kind of a different question. If you're a New Jersey company and you want to make sure that you're complying with New Jersey's equal pay laws, your analysis needs to take into consideration specifically what that statute requires you to look at. And if the statute doesn't say that you can look at the market for folks who are working in other states, and I frankly haven't looked at it that closely in a little while, so I'm not sure that it does, then that's not something that you want to necessarily try to consider as far as Equal Pay Act goes. But that being said, if somebody is moving to another location and you do want to reduce their salary for cost of living, there's not, as far as New Jersey law is concerned, there's not really or federal law, there's not anything that necessarily keeps you from doing that. You just have to follow the state law requirements and notifying them that you're going to be reducing their compensation. You can reduce an employee's compensation as long as you're not doing it for discriminatory reasons, and as long as you provide sufficient notice. Currently, with the labor market being what it is, and as difficult as it is for folks to attract and retain talent, I don't know that that's a best practice, but that's not legal advice. So
that's good.
Worth keeping in mind.
That's good consultative advice. I asked the question like the accountant, where can we cut the costs? Where can we cut the costs? Well, as I'm cutting the costs there, and then they quit, and then you have to pay more for the next person. I don't think I just saved money.
It may not in the big picture, but legally, can you do it? As long as you follow the laws that govern it, yes. But should you right now? Maybe not. You want to look at the long-term cost of doing something like that. And
the people that are on the call appreciate that guidance as much as they appreciate the legal guidance. So we're right at the 9:28 mark. The only thing I ask of you is that you don't call Molly, our HR director, and say he broke X amount of rules in your rule book, because this is a difficult topic. And we have to be very careful as employers and make sure we're handling labor issues properly. The one thing that I love is Google. The one thing I will rarely ever look up on Google is law issues, and labor or law issues, because we know what Google is. It's some of it is a bunch of opinions out there, and even if it directs you to say, sometimes that's opinions. My recommendation is reach out to somebody like Katie. You see all the information she has. Find out before you make a wrong decision, and then there's a lawsuit, and it's not a problem until it's a problem. So the one thing I want to ask of you, Katie, is do you have a closing comment that you'd like to make in general?
Sure. I mean, we talked about a lot of different things today, so we sort of ran the gamut with different topics. One thing that I think, we didn't really necessarily add that I would say is that, to the extent that you want to get out ahead of some of these things, training your employees to make sure that they know what the laws are, especially, one of the things that we've been seeing a lot of requests for is sensitivity training, right? So as far as the more sensitive issues go, making sure that your workforce is informed about how to treat employees respectfully, particularly folks who have a different gender identity. There are trainings that you can offer your management and your employees to make sure that you're having an inclusive environment in your workplace. So that's something to consider. And just generally, as Brad said, it's not a problem until it's a problem. Being as proactive as you can, making sure that your employees' expectations are managed in really all of these areas, right? So people know exactly what they're required to do and what's expected of them. Because the calls that we get that are the frantic calls are the ones where, in some way or another. Somebody didn't know what they were supposed to be doing, or there was a gap between the employer's expectations and the employee's delivery.
Right.
So, we're finding that folks who are more proactive about those things tend to be more successful, and have less conflicts arise.
Great. Well, Katie, you're perfect. I mean, you hit it right on the 9:30 on the button. That's pretty amazing.
You helped.
Not like our tax people that like to go over. I'm kidding. I like the tax department, but I really want to thank you very much for this, and I want to thank everybody for attending. And hope to have you on for future topics. Well, labor issues, but no, I'd love to have you on for future topics. Thank you again.
My pleasure. Thanks, Brad. Take care, everyone.